the Supreme Court judgment on the Insolvency and Bankruptcy Code. A entered into an agreement with B for supply of goods. The value of the goods was $63 million approximately. A, under another agreement, transferred his right, title and interest to M Bank Singapore to collect the money. M Bank issued a notice to B for payment of the money. Under the payment terms, within 150 days of the date of bill of lading, B has to make the payment. Since B failed to make the payment, M Bank issued the notice. Again and again M Bank tried, but B did not budge. So M Bank issued a demand notice under the Insolvency and Bankruptcy Code, that is IBC Code. B failed to make the payment within 10 days. Hence, M Bank made an application before the National Company Law Tribunal, that is the adjudicating authority, for initiating the insolvency process. The application by M Bank was dismissed at the threshold by the adjudicating authority for two reasons. One, the NCLT said that the demand notice was issued by an advocate, hence it is not a valid demand notice under the IBC Code. Two, the application to NCLT as per the section must be accompanied with the invoice, the demand notice, the reply if any given by B, an affidavit by M Bank if there is no reply, a certificate from the financial institution and any other document. NCLT said that since the application is not enclosed with a certificate from the financial institution evidencing the debt, it is not entertainable. On these two grounds, NCLT refused to consider the application for insolvency process. An appeal was filed before the National Company Law Appellate Tribunal, that is NCLAT, which also met the same fate. M Bank approached the Supreme Court. Supreme Court, with regard to issue of notice by the advocate, said that under the Advocates Act, Section 30 contains the word practice. The word practice is a word of wide import. The meaning is very wide. Hence, it includes even a process prior to filing of the application, that is any preparatory work prior to filing of the application is also included in the word practice, and hence an advocate or a lawyer can issue a demand notice on behalf of the company. With regard to the second issue, that is, the application was not accompanied with a certificate from the financial institution, the Supreme Court said that condition is not a mandatory condition. The Act itself says any other document can also be filed, any other document evidencing debt can also be filed along with the application. That means the certificate from the financial institution is not mandatory. Secondly, the Supreme Court looked into Form 5, which is the application to be filed before the NCLT for initiating the insolvency process. In that form, under instructions, it is specifically said that certificate from the financial institution, if available, needs to be enclosed along with the application. The words "if available" clearly proves that the certificate from the financial institution is not a mandatory condition for moving an application for insolvency process before the NCLT. On these grounds,